subsection 2 states that there is a limit on the right of the third party to enforce the term as per section 1, subsection 1b, if on a proper construction of the contract, it appears that the party did not intend the term to be enforceable by the third party. Okay, clear, Shadman? All right. So, section 1, subsection 1a, b, section 1, subsection 2, 1, 3, so far clear? Any questions? No. Okay, so let's move on to section 1, subsection 4, which basically states very simply that if the parties of the contract does not want the third party to be able to enforce the contract, then what they can and a father enter into a contract for the benefit of the son, they can say until the son has graduated or until the son has gotten a job, he cannot enforce this contract. So say for example, if I leave some amount of money to my brother, I say that, okay, I've given you my house, you will pay £100,000 to my son. But the son can only enforce this contract if he has graduated or if he has gotten a job, in order to make sure that my son is actually working for it or some reason, or until he's 80 or until he's 30, he cannot enforce it. So it is possible for the parties of the contract to impose conditions on when a particular, to impose conditions as to when, okay, this is going to follow. Yes. How they take this. So yeah. So yeah. So it's up to the contract as to when he can be able to enforce it. So we are going to write this down. Section 1, subsection 4. Section 1, subsection 4 allows the parties to the contract. Section 1, subsection 4 allows the parties to the contract to impose conditions upon the third party's ability to enforce the contract. So you understood what that means? Okay, so let's move on to section 1, subsection 5, which talks about the remedies available to the third party. So say, for example, C sues A. What remedies would he be able to get?
All remedies that would have been available to him if he had been one of the contracting parties.
Good. So section 1, subsection 5 says that, Silva, do you have that?
Yes.
Okay. Section 1, subsection 5 states that he would be able to get all the remedies that B would also be able to get. So if he was a party to the contract, whatever remedies, damages, specific performance, whatever would be available to him, he would also be, third party would also be able to avail each and every one of those remedies. Okay, so that's one. All right, so let's come to another part of this. See, in this situation, is B capable of suing A? if he doesn't do the job?
Yes.
Good. And under third party right, can C sue A as well?
Yes.
So isn't there double liability for A?
Yes.
But A can
Kill one.
do the same to both.
Yes, but say for example, A breaches, right? A breaches the contract. So B can sue A, C can also sue A. So there is double liability for A, and that is not fair because then B and C would both be able to get damages, and that's going to be unfair to the first party, to A. So what the courts have actually done, they have ensured that there shouldn't be double liability. So Section 5 makes a very important rule. Let's write this down. Section 5 ensures that there will not be double liability. Section 5 ensures that there will not be double liability for the promisor. Section 5 ensures that there will not be double liability for the promisor. As any recovery by the promisee, would have the effect of reducing any award subsequently made to the third party. Okay, so what does that mean? Say, for example, there is a breach by A, and because of that, there has been a loss of £100. Okay? Now, if B sues A first and recovers, say, £50, yeah? So later on, when C would also try to enforce the term, how much can he get? Okay, so anything which has already been gotten by the promisee will be cancelled off. Do you understand what I'm trying to say here?
They're gonna get the same amount.
No, they're not going to get the same amount.
They're gonna get the remaining amount.
Exactly. Let me just cut down the £50, or else people would get that. Who is A is the promisor, and he actually breached the promise.
Why wouldn't B take the entire amount?
Say for example, B sues A, and B gets only £60 of it, because B is not suffering any damage. The damage was the loss is always of C only, because C is the one who's supposed to get the benefit. So if he gets £60 and then later on C also sues him, then how much can C get? Whatever is remaining. So 100 minus 60, which is £40. Okay, so there cannot be double liability. A is a promiser. He made a promise to B that he's going to pay £100 to C for some kind of amount. Now B is suing A, okay, and assume that B wins the case. And he gets, for whatever reason, whatever mitigation, whatever defense that A had, he gets only £60, okay? So later on, if C sues A under our section 1, subsection 1A or B of Third Party Rights Act, how much would he be able to get?
40.
Yes, whatever is remaining between these two. So we
100 that was
the amount that he was supposed to give.
They agreed upon amount.
Yes. This was the maximum amount of damages that they are entitled to. Okay?
It's a little weird now.
Kenna, why is it weird? Isn't it fair?
The court is fair, but
Yeah.
isn't it difficult for the court?
Yeah, but the court is making such calculations every day, so it's not really difficult for the court. Okay? All right, so let's move
What
on.
if C sues before?
Yeah, if C sues before A and he gets whatever amount of money, say he gets 70, if he gets 90, he gets 90. If he gets 100, then B doesn't get anything. So
And B cannot
basically-
get the entire amount.
Huh?
And B cannot get the entire amount.
B cannot get the entire amount because the contract was for the benefit of C. And remember expectation loss, that you would only be put into the position that you were in before if the contract was performed, right? So if the contract was performed, you wouldn't be able to get anything in the first place. So whatever money he gets, he will be getting under the sympathy of the court. If the courts are like nice to him or the courts actually like him, then he may be able to get some damages. But if you look into expectation loss, he's not supposed to get anything because even if the contract was performed, the entire money was supposed to go to C, so B wouldn't get anything in the first place anyway. Clear?
B যদি মরে যায়
That's the problem in it. That should C super.
যদি 60 পার মানে C যদি 60 পার
কিরকম কেসে হতে পারে?
Okay, so let me explain this to you, okay? Say A and B enter into a contract. A is going to serve, A is going to supply potatoes to, B is going to supply potatoes to A, and A is going to pay to C. Okay? And how much was he supposed to pay? Okay? Now what happens, the potatoes are supplied, but this doesn't get paid. Okay? So now A is in breach. His promise to pay £100 was supported by consideration, but he never paid the money. So in this particular situation, who can sue A?
B and C.
B because he's party to the contract, and C because under
S11A and S11B.
you will be able to sue. So whatever money B gets, it's going to be upon the discretion of the court, because who gets the money even if A performs the contract? C gets it. So he is not actually getting any damages. He's not getting actually any losses. So he might be able to get a small amount in order to say that, okay, there was a promise made to him. He did supply the consideration, but he did not get anything for it. So the court might give him, say, £25 or something. Okay, later on, if C sues, then how much would he be able to get? 100 minus 25, which is £75. That's the maximum.
Sure, না হ্যাঁ automatic.
এর থেকে বেশি দিতে পারবে না. So this is the maximum limit of damages that he would be able to get. Clear?
Miss B যদি মরে যায় তারপর C সু করলো C কত পাবে? C কি 100 পাবে?
Depends on the court. If the court believes that hey, kind of C কোনো fault ছিল না, or A doesn't have any defenses, then
C কি 100 দিতে পারবে? মানে ওইটা
yeah, it's up to the court. Yeah, it's up to the court. Okay, so it depends on the facts, the individual facts of the case. All right, so let's move on. Now let's come to defenses. What are the defenses that are available to A?
Frustration.
In this relationship with C, who's suing? এখন C versus A হচ্ছে, right? B কে এখন ভুলে যাও. In a cause of action or in a suit between C and A, what defenses are available to A?
Frustration.
No, not frustration. Basically,
So ধরেন পেট ব্যথার জন্য দিতে পারে নাই।
basically, section 3, subsection 2 of the Act. Did you write this down?
No.
No? So let's write this down now. Section 3, subsection 2 of the Act provides you with the reason what defenses would be available. Basically, any defense that would be available to him if B had sued him. So any defense that he would be able to get against B, he would be able to get against C. Okay, so let's write this down. Section 3, subsection 2 states that Section 3, subsection 2 states that the promiser will be able to rely on any defense. The promisor will be able to rely on any defense arising out of the contract. The promisor will be able to rely on any defense arising out of the contract which would be available to him, against the promisee. Against the promisee. Okay. So therefore, say for example, there was a misrepresentation done by B, and that was the reason A entered into this contract. Then would he be able to rely on misrepresentation as a defense in the case between C and A? The answer is yes. So basically, any defense that he has against B, he would be able to rely against C. Clear, everyone? All right, so let's move on to the next concept. Can you vary or cancel this rights? Say, for example, A and B enter into a contract whereby A agrees to pay a sum of money to C. Now, after a certain period of time, B and C have a fight, and B and A decide that they're going to change the contract. Can you do that without the consent of C? I'm going to repeat that just so that you know what I'm talking about. A and B enter into a contract where A has to pay some money to C. Clear? And after a point, say a few months later, B and C have a fight, and B decides, I wouldn't give any money to C. Can A and B, without the consent of C, change the contract?
Yes.
Okay, so we'll talk about this. So let's write a nice little heading called variation and cancellation. Variation and cancellation of the contract. Variation and cancellation of the contract. Now this is dealt with by section 2. Okay, so what does section 2 talk about?
Variation and cancellation.
Yes, right. But what does it say exactly? So let's write that down. Section 2 states that unless the contract provides otherwise, the parties to the contract, unless the contract provides otherwise, the parties to the contract may not change it to extinguish or change the third party rights, if A, the third party has communicated to the promisor, his assent to the promisor, his assent to the term, or B, the promisor is aware, that the third party has relied on the term, or B, the third party is aware, the promisor is aware that the third party has relied on the term, or C, the promisor reasonably foresaw that the third party would rely on the term. Okay, so there are a few things. First of all, like the SNUVA said, unless it is expressly excluded in the contract, you would be able to change or alter it, except for three situations. Situation number one, when C has accepted, assented manunche acceptance, right? If he has accepted the term and he has told the promisor that I accept this term, okay? Situation number two, B knows that C has relied on this term. So say for example, C has told B, oh, I know I'm going to get this much amount of money from A, so I am taking a loan to study because I know I can pay it back when A pays me. So he knows he has relied on it. Or number C, B foresaw that C would rely on it. He kind of expected it that C would rely on this term. Clear, everyone? So in these three situations, if A and B had to alter the term or cancel the term, they can only do so if C consents. So if he doesn't consent, they cannot change it. Shadman, are you with me? All right.
C must consent.
Must consent in these three situations. Okay.
And if without these three situations?
You can change and vary and cancel it. So, so who has the burden of proving that C has relied on the term? The third party. C has to prove that he has relied on this term so that the cancellation is not done. Okay. However, if like say for example, the SNUVA and I enter into a contract whereby we pay £50,000 to you, okay, and then we decide all of a sudden that we don't like you, and then we want to cancel you out of the contract. Can we do that? The answer is yes. So let me just explain it like this again to bhenge.
না মিস কন্ট্রাক্টে যদি বলা থাকে যে আমার কনসেন্ট লাগবে না তাহলে আপনারা এটা করতে পারেন।
Wait.
এমনিতে তো আপনাদেরকে তো এই তিনটা কন্ডিশন তো মানতে হবে।
Wait. A, B, C.
আমি এটা করতেই পারবো until unless এই তিনটা conditions থাকে।
A and B basically enter into a contract where B বলে you pay me 50% of the purchase price and you pay C 50% of the purchase price. Clear? Now, suddenly B decides that he wants to change it and he wants to get all of the 100% of it. So he has to cancel and get this clause out. Unless it is stated in the contract, otherwise, he would be able to vary and cancel it except in three situations. Situation number one, when B expressly told A, I accept this term, or B knew that C would rely on it, and the third one, he reasonably expected C to rely on it. These three conditions. Clear, Shadman? Are you with me? You're not with me? Hello?
Yes.
Acha. Okay. All right, so let's move on. However, if we have a clause in the contract, yeah, if we have a clause in the contract where we expressly state, we can vary and cancel this right anytime we want. Okay, so আমাদের দুজনের clause, আমাদের দুজনের contract, initially we had this clause where we stated that okay, this is the terms, but we can cancel the right of C anytime we want without his consent, and this is in the original contract. Then we don't really need to comply and get his consent anyway.
Because doesn't just C rely for a YouTube, no?
Exactly, because we have always retained the right to cancel it. Clear? So that's given in section 2, subsection 3. So let's write this down. Section 2, subsection 3A. Section 2, subsection 3A. Section 2, subsection 3A provides. Section 2, subsection 3A provides the contracting parties can agree to vary the contract. The contracting parties can agree to vary the contract without the consent of the third party, if they reserve the right to do so in the contract. Continuation. The court is also given the power. To dispense with the third party's consent. Where the consent cannot be obtained. With the third party's consent, where the consent cannot be obtained because the third party cannot be located, or is mentally incapable.
I'm lost. I'll get from
Okay, let me go a little slower. Where did you guys get lost?
the third party is the
Only
power to dispense with the third party's consent.
Where the consent cannot be obtained, because the third party cannot be located, or is mentally incapable of giving consent. Section 2, subsection 4. What does that mean? That means that the court has the power to say that, okay, there's no need to get the third party's consent. Because we can't find him. Or he has a mental disease, so he's not mentally capable of giving his consent.
This is section 2, subsection 3A, right?
No, this is section 2, subsection 4.
No, it's
Yeah, it is.
not restrictable into 2-3A.
3A was, it is open to the contracting parties to resign. That's 3A. And now the one that I talked about, the court, that's 4. Section 2, subsection 4. Okay. Let me just explain this to you. The first part of the sentence, which ends at by reserving the right to do so in their contract, that's section 2, subsection 3A. Then the one about the court is section 2, subsection 4. Clear? Continuation of the paragraph. And there is a limit to spoon feeding, so just read it and you'll understand. Use it a bit of your brain. That would be very helpful. Okay, so another time where the court can actually dispense off with the consent of the third party is if the third party has not relied on the term. And that is stated in section 2, subsection 5, but it is a continuation of the paragraph that you are going to write, but it's a different section. So let's continue with the paragraph. Where did it end? He's incapable of giving his consent. Then in a bracket write section 2 subsection 4 and then continue, or where it cannot be ascertained, or where it cannot be ascertained.
This is section what?
I'll tell you. Or where it cannot be ascertained, or where it cannot be ascertained whether the party, or where it cannot be ascertained whether the party has in fact relied on the contract. Okay? This, and then open a bracket and write section 2 subsection 5. Okay? Clear, everybody?
Yes, miss.
Finally. So let's move on. So that's basically it about from the statutory view. That's all you need to know from the statute. Okay, so now any questions on the point of statute? If you have any questions, then please ask me. And if the ones who are actually viewing the link have any questions, then post them on Facebook and I'll get back to you. All right, so let's move on to the next idea. So APACON, what did we learn? We learned what is the privity of contract and what are its statutory exceptions. Basically, that's all we have learned so far. Now, so many exceptions, so many rules to basically remember. Then we have to basically move forward and see what are the common law exceptions. So we're now going to write a heading called the common law exceptions. Okay. One of the first things that you need to know is that when the Contract Rights of Third Parties Act came into place, they specifically mentioned that they have not abolished the existing exceptions. So in section 7, it was specifically mentioned that the previous common law exceptions are still legal, authoritative, and are not abolished or repealed. Do you understand? So section 7 of Contracts Right of Third Parties Act 1999 stated that the common law exceptions were still available and not abolished.
Section 7.
Yeah. Okay. So what are these exceptions? Exception number 1, enforcement by the promisee. We have mentioned that B is always able to enforce this contract. So exception number 1 is we can just ask B to enforce the contract on behalf of C. And this is again mentioned in section 4 of 1999 Act, if you want to write it down. So do you want to write this down? Section 4 of Contracts Right of Third Parties Act 1999 states that the right section 4 ta bole J, let's write this down. The creation of the new third party rights, the creation of the new third party rights does not affect the right of the promisee, does not affect the right of the promisee to enforce the contract. Okay, so we basically have A and B and C, and B is able to enforce it even after we are allowing C to be able to have the right to enforce the contract. Okay, so B, the fact that B could enforce the contract is not being affected by any of the statutory provisions we have written so far. So what
So
is
যদি amendment এনে ARP এর মধ্যে যে কন্ট্রাক্ট এটার মধ্যে amendment এনে যদি আরেকটা পার্টিকে ইন্ট্রোডিউস করতে চায় যেমন ডি তখন কি হবে? তখন কি এই একই জিনিস অ্যাপ্লাই করবে যে তখন তো এর এগেইনস্টে তিনটা ক্লেম আসে এই যদি
you're saying that there are two third parties. So basically again the same rule applies.
আবার এই 100 থেকে 25 বাকি যা আছে
that's the thing. Okay, so what are the problems with the enforcement by B? The problem with the enforcement, number one, B might be unwilling to enforce the contract because he doesn't want to enforce the contract. And number two is, even if he is successful in suing A and getting a successful case, what is the measure of damages that B will be able to get? What is the amount of damages that B will be able to get?
Zero.
Because let's just go back a few classes. We talked about expectation loss. What is expectation loss?
Losses which arise out of and
Basically, if there is a breach of contract, we try and fulfill the person's expectation loss under the contract. What is the idea behind this? The idea behind this is to try and put B in the position that he would have been if the contract was performed. We have actually written this down in one class, okay? So let me repeat that again. The idea of expectation loss is to try and put B in the position that he would have been if the contract was performed. If this contract was performed, then would B get anything? So let me just say it. Say A says, I will give you, we'll just keep to the potatoes, and he will pay 100 pounds to C. Now, if A breaches the contract, then C doesn't get 100 pounds, right? But even if contract is performed, then how much money will B get under the contract? Zero. And if the contract is not performed, zero. So he doesn't have any loss. There is no expectation loss in relation to B. So there is a lot of problems in deciding what amount of damages should B be able to get. Okay, so this is one problem that we have because B has not lost anything because of that. But one possible view and one theory that the courts have time and again talked about is that B has a performance interest. Even though he doesn't have a normal interest in it, he does have a performance interest in it. That means he wanted it to be performed. So because of that, he might be able to get some minimum damages from the court. So we're going to write everything that I just said in a very short paragraph so that you don't forget it. So let's write that down. It is very difficult to ascertain. It is very difficult to ascertain what will be the adequate remedy. What will be the adequate remedy in cases where the promise was made, in cases where the promise was made solely, in cases where the promise was made solely for the benefit of the third party. Okay,
Thank you. For the benefit of the third party. Stop. The courts have usually gone for an order for specific performance. The courts have usually gone for an order for specific performance. And the name of the case that we're going to look into is Woodard versus Wimpy.
Principal था कौन सा देश हुआ?
Specific performance.
Woodard versus Wimpy.
The courts have usually gone for an order for specific performance. Full stop. Another possible view is that B has a performance interest. B has a performance interest in the contract. B has a performance interest in the contract, and damages should be awarded. And damages should be awarded to B. And damages should be awarded to B. Thanatown versus Alfred McAlpine. Thanatown versus Alfred McAlpine.
Woodard versus Wimpy is the case.
For specific performance, and this one is for performance interest. Okay, but there are, so basically what we're learning is that even if B wins the case, the courts have a very difficult time to actually understand what is the measure of damages that he is entitled to. So it's very difficult to understand what amount of damages we'll give to B. But
Specific performance.
you don't know what's the meaning of specific performance? Okay. Say, for example, if I and the Suva enter into this contract to buy a piece of land or this piece of land, then what happens in this situation is that every land is unique, right? So she would be able to get some land, which is probably the same amount, or which is same acres, or which is the same price, but she wouldn't be able to get this same exact land anywhere else. So in these situations where the product is very unique, money is not held to be adequate compensation. So when the contract is for something which is not compensated adequately by money, then we order specific performance, which basically means if I refuse to sell her the land, she can go to the court and the court will order me, you have to sell it to her. Do you understand? So in this situation, what would happen is they will tell A, you have to pay C £100. That the fact that you're not paying £100 to C, we're not going to accept any compensation. You have to give it to C. Did you get it? Good. All right. So there are situations where B would be able to recover some money on behalf of the third party. What are these situations? Situation number one, let's say, for example, when we go to a hotel, a vacation, a family vacation, who books the hotels? Father, right? যখন আপনারা বাইরে ঘুরতে যান, হোটেল কার নামে বুক করে room? Your father, obviously, most of the situations. So say, for example, 6-7 kids and everybody goes there, everyone has a different room. Now, because say, for example, the hotel has done a very bad service and someone gets injured or they've breached their contract. So they said that they'll give you seaside rooms. They haven't given you a seaside room. They said that lunch is free or breakfast is free. They have done misrepresentation. Now, in this situation, B is actually, so they were promising benefit to the entire families, to 6 different people. So say £100 to 6 different people is equal to £600. So can the father who has a contract with the hotel recover for all of us? The answer is yes. Let me rephrase that, or let me just repeat that. A takes his 5 children to holiday. And when he goes to the hotel promises him, we'll give you breakfast, this is a seaside hotel, and they make a lot of misrepresentation, okay? So the contract is between H and the father, the hotel and the father, okay? Because they are the ones who have entered into the contract. But it is for the benefit for each of his children. They're all third parties. Is everyone with me so far? I know it's been a long class, but just bear with me for 10 more minutes. Okay, so each of them gets that. So each of these people, say for example, have an expectation loss of £100. So that's £500. So can the father recover the money for each of the kids? Well, in the case of Jackson versus Horizon Holidays, they allowed him to. Okay, so let's write this down. Multiple bookings. Multiple bookings. In Jackson versus Horizon Holidays, Lord Denning, Lord Denning held that a person who booked a holiday on behalf of himself, and family members was able to recover damages on behalf of his family members. Okay, everyone understood that? Okay, situation number 2. Say for example, if I am a seller of goods and I contract with the buyer. So let's say for example, A buys goods from B. All right, A buys goods from B. B contracts with C that you have to transport the goods to A. Okay, and what happens in this situation is that the moment he pays the purchase price, he no longer has any interest in the goods because it belongs to A now. So if C damages the goods, should B be able to recover any money? Well, the courts have allowed them to do so in the case of Albazero. Okay, Albazero. So let's write this down.
Why is it's so contradictory?
It is kind of. Let me tell you in this situation. There is a contract between the seller and the carrier, right? That B and C, that you have transferred the goods. And there is a separate contract between A and B. But the problem is that the moment he pays the money, he becomes the owner of the good and he has no interest in the goods. So even if C does damage the good, B should not be able to recover any damages. Okay, but in the case of the Albazero, Lord Diplock stated that in such a situation, you would be able to get some damages. Okay, so let's write this down. In the Albazero, Lord Diplock recognized the limited ability the limited ability of the seller to recover substantial damages on behalf of the buyer where goods are lost or damaged. Of the buyer where the goods are lost or damaged by the transportation company. Okay. And does anyone have any questions about the Alpha Zero?
Is it a ship?
No, it's the name of the company, it's the name of the transportation company.
Okay. So on that note, because I can see your tired faces, it's been a long 2-hour class, we're going to end it on this note. There is a very small paragraph left about it. We're going to do that next class, inshallah, which is going to be this Wednesday. Do you want to finish it off? Acha. So basically what we next need to look into is the second exception, that's agency. Yes. What agency basically means is it's not exactly only an exception to the privity of contract. It is a normal principle. So what does agency basically mean? Agency means if A enters into a contract of B, who is contracting on behalf of C or as an agent of C, right? Then ultimately we think that the contract is between A and C, right? Because he is either the lawyer or the employee of C. So ultimately the contract is between A and C. So that's the principle of agency. Everybody clear on that? Did you understand? No. Say for example, C lives in London, okay? He wants to sell his land to someone. So he tells his lawyer, who is B, that please sell my land. And B says, I can only be able to sell your land if you give me the power of attorney. So B has the power of attorney. He contracts with A. A and B enter into a contract, but B is only an agent of C, right? So ultimately, who are the parties to the contract? According to law, B is just an agent of C. So the contract is between A and C. Clear? Okay. That's agency. Well, agency is kind of interesting in the sense that it's very simple. It doesn't have much of problems there as well. So let's just move forward. Okay. Let's come back to Scruttons versus Midland. Remember the case where A and B entered into a contract, and then if there was a contract with the third party to actually transport the goods to A. So this is also the case of the Uri Medin. What happened in this case was very simple. Basically, this is what happened in the case. There was a party which basically entered into a contract for the goods. So basically, A bought goods from B, and B contracted with C to deliver the goods to A. C damaged the goods. Okay, and there was a contract. There was a term in the contract between A and B, which stated that B is not liable for any damage done to the goods when transportation is being done. Question is, can C rely on this exclusion clause? No, according to Scruttons versus Midland, no. But Eurymedon actually created a very interesting idea. What they basically stated was that they had a couple of rules which they had to follow, and this was actually created by Lord Reeds. Lord Reed in Scruton versus Midland basically talked about 4 rules, and this was accepted by the Privy Council in Eurymedon. So let's write down these 4 rules. In the Eurymedon, the Privy Council held that if the contract makes it clear that the transportation company is intended to be protected by the provisions of the contract, then the transportation company would be able to rely on the exclusion clause, in the contract. Full stop. This is because when the seller entered into a contract with the transportation company, they made a unilateral offer. That anyone who unloaded their goods would be entitled to the benefit of the exclusion clause. Okay. So basically what happens is, in this situation, C would be able to rely on the exclusion clause, because the Eurymedon moves on from the idea that C is working as an agent of B. Clear, everybody? Good. All right. So let's move on to the next exception.
Just a small paragraph was there.
Right. Okay. No, we do have a couple of exceptions left, but shouldn't take much time. What?
Or killer looks.
Acha, fine. Let's just do one more and then we'll do the next later, okay? All right, so the next exception is collateral contracts. The next exception is collateral contracts. What do you know about collateral contracts? Collateral contracts mean additional contracts. So there's a main contract, there's a principal contract, and then there is an additional contract. So let me explain that to you.
The contract regarding the contract. More company
mostly basically because it would be something like
a time frame.
No, it would be something like, say for example, if I am asset limited and I am making a building here, I would obviously have a contract with the company, say who supplies me bricks. Okay, so that is my main principal contract. But at the same time, they have a liability to transport the bricks to me as well. So I have a principal contract of getting the bricks and cement from this company. I also have an additional smaller contract that you will transport this to me. For example, if you go and buy furniture, they'll give you two things. Number one, receipt, and then they'll give you also chalan. So basically, this is what my transportation person is going to ask from you. So that's a collateral contract. There are two contracts there. One is the main contract for your furniture, and the other one is your additional contract. So what the courts basically try to say is that occasionally a third party may be seen that, okay, there is a contract between A and B, and then there is a collateral contract between A and C. So we're just going to see two cases here, and then we're done. So no one has to kill Chapman for it. One is Shanklin versus Dettel. Let me just write that, please. So what happened in Shanklin versus Dettel was that certain contractors were employed by the claimants to paint the claimant's property. And they were instructed by the claimants, please use the paint made by the defendants. Okay. So the contract to purchase the paint was made between the contractors and the defendants. But, so let me just explain this to you. Okay. So I asked someone, A asked B to paint their factory. Okay. C to representation korsilo. J, my paint is very good. So A tells B, J paint kinba holo C company kastake. Okay. So the court kind of basically CJ bolsilo our paint is very good quality. Later on, it turned out to be not a good quality. So B could obviously sue C, but could A sue C? The court held that while there was a contract between B and C, which was the principal contract, the fact that C made a representation to B meant that there was a collateral contract with A. Did you understand? The main contract is between B and C, but only reason that B brought the paint from C is because A wanted them to, and because there was a representation made by C to A, this was treated as a collateral contract. So they could sue C under the principal contract and A could sue C under the collateral contract. Clear? Shall we write this down? Let's write this down. In Shanklin versus Dettel, the court held that in Shanklin versus Dettel, the court held that A was entitled to bring an action. A was entitled to bring an action for breach of contract on the ground that there was a collateral contract, between them. However, a court is very reluctant However, a court is very reluctant to find the existence of a collateral contract when the parties are experienced commercial parties.
To find
Collateral contracts where the parties are experienced commercial parties.
existence of the collateral contract.
Where the parties are experienced commercial parties. Okay. আপনারা hire purchase এর ব্যাপারে কি জানেন?
Loan ekena.
Good.
Installments pay for.
The ownership transfers after the last installment.
Good. So what happens in a hire purchase? Say for example, if this is a road, it's a continuation of the same etc. So I'm not starting off something new, but I'm just explaining this to you further. So say for example, I want to buy a car from Shamran. Okay, so he's the dealer and I am the consumer. How can I do that? Well, Shadman আমাকে first বলবে যে the car is really good, it's got a lot of great roadworthiness and its mileage অনেক কম, so basically he makes a lot of lies to me. I go to the bank and I tell them I want to buy this, okay? So the bank buys the property from Shadman. Yeah, the bank buys the property from Shadman. And then the bank has a contract with me, okay? The bank has a contract with me that after you finish paying the last installment, this car becomes yours. Clear? So what are the two contracts between me and, between the bank and Shadman and between me and the bank? There is no contract between me and Shadman. So if this lie, if I want to sue him for this, can I sue him under breach of contract because he has breached his term? No, because I don't have a contract with him, right? But in Andrews versus Hopkinson, the court held that the fact that he made this comment to me, and because there is this kind of a interrelated contracts between us, there is a collateral contract between me and him. Clear? All right, so let's write this down. And that's the last case for today, I promise you. Andrews versus Hopkinson. In Andrews versus Hopkinson, it was held that the dealer's false warranty about the roadworthiness of a car, gave rise to a collateral contract between the dealer and the consumer, and thereby allowing the consumer to bring an action against the dealer. Okay, any questions so far? Next class, we're going to completely finish this chapter. There are little bits and pieces left of it. Once we finish that off, we're going to do a question. So there's going to be a question done tomorrow, next class as well. We're hoping that would be this Wednesday, assuming there wouldn't be any hartal or anything. So on that note, let me dismiss the class. Okay, so I'll see you next class.
Thank you, miss.